Morning, everyone. Welcome to the next in our series of commercial webinars. The talk today is on without notice applications and the duty of full and frank disclosure. For those who haven't met us, my name's Neil Berragan. I'll be speaking briefly on the grounds upon which an application can be made without notice. Doug will then address the duty of full and frank disclosure, and then I'll say a few words about the sanctions that are available for breach of that duty. As I'm sure you're all aware, the general rule is that any application for an injunction, indeed any application for an order against another party, should be on notice, and the usual rule is that that should be on 3 days notice. However, there are circumstances, of course, in which an application is made without notice, but there must be a good reason not to give notice. The practice direction summarizes effectively what the authorities have established over many years, which is that there must either be exceptional urgency or where the overriding objective is best furthered by not giving notice. And that's another way of saying, if we go to the following slide, that notice would or might defeat the object of the application. And typically, of course, where an application is made for a freezing injunction, it's important not to give notice to the respondent, as that might defeat the object of the application. But that is not an invariable rule. And there are circumstances in which you can take the view, and I have certainly experienced this, and there are authorities where this has occurred, that even when you're applying for a freezing injunction, the nature of the assets that you wish to seize are such that it is unlikely that the respondent would be able to dispose of them immediately, even if they had notice of the application. And in those circumstances, you may well be advised to give some notice at least. The practice direction and the authorities envisage that you might be able to make an application simply because there is insufficient time. But paragraph 4 of the practice direction strongly indicates that you should always give notice, even if it has to be very short. And with modern methods of communication, it's difficult to envisage circumstances in which you do not have grounds for not giving notice, i.e. you cannot show that the application would be defeated if notice was given, but you wish to argue that you simply didn't have enough time. As G.on commercial injunction says, normally it's possible to give notice by email, text or telephone, and to do so in minutes. So even if you are on your way to court, you can still telephone the respondent and give notice of the application. However, if you do so, whether or not the respondent attends, you will still be under the duty of full and fair disclosure, because this will not be formally an on-notice application. Then we can move to the next slide. Of course, there are exceptions, and as the practice direction and rules envisaged, there may be orders, rules, practice directions, or circumstances set out in the Commercial Court or Chancery Guide where you are allowed to make an application without notice. But it's important to remember, as a general rule, that the duty of full and fair disclosure applies to any without notice application. And for example, that includes an application for permission to serve out of the jurisdiction, where there is a heavy duty to ensure that the applicant makes a fair presentation of the merits of the claim they wish to bring and of any prospective defence that is likely to be raised. I think that's all I was going to say on the point of without notice applications, and I'll hand over to Doug.
Good morning. We'll move on to the duty of full and frank disclosure. which is at the heart of the without notice regime, as I think all of us will be aware. Right from the start, I think there's two principles that I'd like us to keep in mind as we consider what the duty of full and frank disclosure means. The first is, as various authorities have reiterated on numerous occasions, it is the quid pro quo for the benefit of the without notice element. The usual expectation of courts in the courts is that both sides will have their say before the judge makes the decision. In the case of full and frank disclosure, it arises precisely because that isn't the case, because one party has been deprived of its normal rights in respect of getting a chance to put their case before the court. Because they aren't there to do it, you have to do it for them. The second thing I want to say that at the outset, which is a thread that binds the whole process of full and frank disclosure together, is that as we're thinking about what full and frank disclosure demands, I think it would be as well that we consider what the consequences will be, or could be if we get it wrong. Neil's going to speak in a moment about what happens if there is material non-disclosure. So when we're giving full and frank disclosure in the first place, I think it's as well that we bear in mind how we could be criticised. We know that prior to the return date, that our opponent is going to comb through everything we've done and to try and fault find and nitpick. So full and frank disclosure will mean that we try as far as possible of depriving them of any argument to say that we've misled the court or that we haven't complied with our duty in full. And if we try and, as it were, take all their arguments away from them, they might wish to raise at the return hearing, we'll probably end up doing our duty of full and frank disclosure anyway. There are various cases, of course, which have restated and stated principles that underlie what full and frank disclosure involves. I've sort of broken them down boldly into three main categories: information, investigation, and presentation, just so I can use those as a framing mechanism for looking at the regime. Firstly, on information, the starting point is something that Neil's already touched on. The evidence should always cover, the evidence that we present should always cover why it was that notice was not given. And as Neil's already covered, it should also set out what, if any, informal notice was given, be that by telephone, email, etc. Certainly I've been on applications before where we've given reasons why it is that there was no formal notice given through the solicitors of the other party. But the question then comes from the court, did you give any informal notice? Was there an email? Was there a phone call, etc.? Ideally, that will be set out in evidence. Though, as Neil says, sometimes that will take the form of something as informal as a phone call while you're on your way to court. Of the three limbs that I've set out, information, investigation, and presentation, I think information is the one that we intuitively associate most easily with the full and frank disclosure regime. A classic statement of that is the Fitzgerald and Williams case, which I've cited here. Any fact known to the applicant which might affect the judge's decision whether to grant relief or what relief to grant. I don't think that requires any elaboration. I think it's what we associate with the duty of full and frank disclosure to begin with. Large of my presentation today is going to be directed at showing there's more to it than that. The Alliance Bank and Zunis case is often used as setting out 7 principles which are relevant to the duty of full and frank disclosure, and I think which neatly divide into the 3 categories I've set out. What I want to draw out from the first 2 principles, which speak to the duty to provide information, is the duty of utmost good faith. Again, as I emphasized from the outset, what makes the full and frank disclosure regime different and important is that we have to stand in the shoes of the other party trying to put forward the arguments that they would like to make. That means that we have to behave with utmost good faith. And as a result, have to be a bit less partisan than we would ordinarily be. In short, if the duty of full and frank disclosure sounds onerous, that's because it is. And it's not a duty that we want to take up because we fear, for example, tipping off the other side good defences they might have, then we probably shouldn't be contemplating it to begin with. Another restatement of the law here is in UKIP and Brain, a case I'll speak about in a minute, points out that duty goes into the duty to provide full and frank disclosure, goes into the additional facts that ought to have been known to the applicant if they've made proper inquiries before the application. That in turn leads into the second limb I want to discuss, that is investigation. I think it's a helpful way of framing the duty of full and frank disclosure to think about it in terms of the way in which we think about disclosure in normal civil litigation. When we think about the disclosure that we have to give information, we have to reveal documents that either speak to why our case is likely to be successful or unsuccessful, but also matters that might support or undermine the other side's case. So if we put ourselves in the shoes of the court and ask what it is that the court might wish to know, and we put ourselves in the shoes of our opponent and ask ourselves what it is that our opponent would like the court to know, we're likely to cover most of the elements that go into full and frank disclosure, and we've got a good chance of making good our obligation. So we've compiled all of the information that we have. We've assembled it. We've not left anything back. We've stapled it all together to a witness statement, said to the court, here are the relevant documents. Have we done enough? Well, unsurprisingly, the answer to that question is no. The information requirement is supplemented by a duty of investigation. As the Alliance Banking and Zenas case points out, we have a duty to investigate the facts and fairly to present the evidence. Now, that duty of investigation, as I've covered already, means that we need to do more than simply say what we already know. We are under a duty to investigate and to go further, to find out those facts which should have been reasonably apparent to us, and then to present those to the court. The further point to make here, and I've covered under investigation, could have been covered under any of the headings. The investigation that we embark upon is not simply an investigation of fact, it's an investigation of law. We're required, in addition to our duty to investigate the relevant facts of the case, to do legal research as much as might be necessary to put the court on a notice of defences that might be raised and what might be said for the defendant. So in the UKIP and Brain case, one of the things that the applicant was criticised for was not taking the court's drawing the court's attention to the human rights points that were raised by the application and indeed the points that would be taken under the Human Rights Act. How does investigation jive with the fact that in most cases, and hopefully all cases, there's going to be some sort of urgency? So I've just said a moment ago, we have to do investigation, we have to do research. But it seems to us that seems to be in conflict with the usual run-of-the-mill without notice application, in which there's a sense of urgency. Otherwise, simply make a normal application on notice. How do we reconcile those two objectives? And the answer is with difficulty. The Brinksmart case makes clear that one of the points that the court will make when it considers what would be a material non-disclosure is a degree of legitimate urgency at the time available for the making of inquiries. That's point Roman numeral 4 at C. But that has to be balanced by the nature of the application, the nature of the case which the applicant is making, and the probable effect of the order on the defendant. So obviously a more onerous order on the defendant will involve greater duties of investigation upon our part. Less onerous will be in cases where the effect is less onerous. And there may be a degree of legitimate urgency which confines the extent to which we're able to make the sorts of investigations the court would ordinarily want. The main point to make under investigation, I think if there's one thing you take away from this head, it would be this, is that the way the investigation duty is enforced by the court is by making the applicant accountable for the facts that they ought to have known about as a matter of deciding whether or not there's been material non-disclosure. So even if there is positive evidence that the applicant had no idea that a certain relevant fact was the case, it is a material non-disclosure if that relevant fact ought to have been known to them had they undertaken the relevant inquiries. There is, however, a difference between innocence and guilt. That is to say, an innocent failure and a guilty failure to make a disclosure in terms of the consequences that come. I'll leave Neil to cover that in a moment. But suffice it to say, it is no defence to say I didn't know. If the correct response can be given by the respondent, well, you want to have. A good case study of that is actually the Rogachev and Goryanov case, where there was a suite of material non-disclosures and failures identified by the court in securing, in making the application for without notice. There were a number of breaches of the duty of full and frank disclosure. And I think one of the things that made this case interesting was the spotlight that it threw on the duty of investigation. In this case, the case concerned a number of property interests, including a Moscow market site in respect of which ownership was disputed. And critical to the assessment of the strength of the parties' cases was the fact that there was an advert on a Russian property website which the applicant had not brought to the court's attention. Now, as it happens, there was no evidence the claimants knew that this advert existed. But nevertheless, it was catalogued among their failings that it was not brought to the court's attention, because even though there was, as I say, no evidence they knew about it, the evidence was that reasonable investigation would have shown them. Okay, so we've covered the first two limbs, information and investigation. So we've gone further, and we've not only told the court everything we know, but we've then gone on to do a little bit better. We said we've carried out investigations, we've found out more. Not only have we done factual investigations, where we've scoured Russian property websites looking for relevant adverts, we've also done legal research. We've identified those points that will be relevant to court's analysis, and we've brought them to the court's attention. Have we done enough? And the answer is no, because of the third limb, which is presentation. And again, if there is one thing I would take away from the duty of full and frank disclosure as it pertains to presentation, it's this. It's not good enough to say it's in there somewhere. It's not good enough to say I handed the court an exhibit of 500 pages, and if you looked at page 310, you'd have seen exactly the email the other side is bouncing up and down that's saying it would have been presented to the court. So the fact that the evidence has been given to the court, that it's been investigated, that it's been found, it's been shown, is not sufficient. It has to be linked to the duty of a fair presentation. It has to be presented to the court in a way that the court is able to grasp what the strengths and weaknesses of the argument are and have its implications known. I think that's especially true when you consider that many applications made without notice are often made by telephone, in which case it's very obvious that there will be a duty of presentation where the court won't necessarily have relevant papers at its fingertips. The rest of the law and rest of Berragan counsel is just another restatement of the principle I've already articulated. And again, I think that the easy test for deciding whether or not we've made fair presentation is to think about what the other side would be doing if they were there. If the other side were presenting their case, they wouldn't simply say, I've got the evidence in there somewhere. Here's a bullet point, a set of the legal principles. Here's some exciting emails, etc., etc. What the other side would be doing, if they were there, is they would be saying to the court, please go to this email. I want you to read paragraph 3. And the importance of that email for our case is that it buttresses this critical point of the defense, or it means that the applicant's ultimate desire for relief X, Y, and Z is unlikely to be something that you'll grant following trial. So if as far as possible we simulate what it is the other side would be doing in their presentation of the evidence, it's a higher likelihood that we'll be complying with our duty of full and frank disclosure. And that simulation is precisely what the full and frank disclosure regime is designed to achieve. It's designed to achieve a substitution, as I've said before, for what would be the usual presence of the opponent in circumstances where the opponent cannot be present. Finally, just a brief note. Fein Vestens and Tomlinson is a reminder to produce a full hearing note that should be provided to the respondent, whether or not the respondent requests it. That was a case in which it was cited, the failure to produce notes, as a breach, albeit on the fact it wasn't found to have been particularly significant. But it is nevertheless an ordinary duty of seeking without notice relief that such a notice produced, and then in turn that notice produced to the respondent. Of course, that's a very good way of that discipline is a very good way if a good transcript is taken of ensuring that we've complied with our duty of full and frank disclosure by setting out what documents we've taken the court to and what arguments have been put that would be put ordinarily by the respondent. It's not enough, as I've said earlier, that we end up in a circumstance where we can say that the matters were before the court. They have to be presented in such a way one understands their significance. A number of questions coming in. We'll deal with those if we have time at the very end.
If you're faced then as a respondent with an injunction and you consider that the injunction appears to be unjustified, and in particular that on the face of it, it appears that it has been obtained without compliance with the duty of full and fair disclosure, which Doug has just been discussing, then what are your options? Well, the obvious option, and one that is typically employed, because we are usually here dealing with hard-fought commercial litigation, is to make an application to discharge. That obviously raises the temperature. It introduces another piece of satellite litigation, and it increases the costs. But it is frequently deployed in cases of this nature. You need to understand, of course, and the client needs to understand, that that's not the same thing as exercising your right to oppose the continuation of the injunction on the return date. Typically, of course, if an injunction has been granted without notice, in fact, almost invariably, if an injunction has been granted without notice against identified parties, certainly in commercial litigation, a return date will be fixed. If the injunction is being opposed, then although the return date may well have been fixed within a few days, often only 7 days after the initial hearing, one might expect there to be quite a considerable adjournment as the parties marshal their evidence. You don't have to make a formal application to discharge on the grounds of non-disclosure. You can simply oppose the continuation on the basis that you will put forward the full facts, which you can argue show that the injunction was not actually justified on the merits in the first place. Moving on, though, if you are making the application to discharge, then a procedural point, you obviously have to, on this occasion, you can't do it without notice, you have to give notice. And it's important that you give adequate notice, in other words, sufficient notice to enable the other side to prepare. Typically, you would give that, if time allows, before the hearing of before the return date, i.e. the continuation hearing. And it would be sensible, I would suggest, if you're not able to give formal notice at that stage, at least to give informal notice that you are intending to make an application to discharge on the grounds of non-disclosure. When you do assemble the application, then the application and the evidence must, of course, contain sufficient particulars to enable the initial applicant to understand the case that you're now making against them. The sanction that you're seeking, discharge, is described perhaps informally as a penal sanction, not quite the same as a penal sanction against an individual resulting in fine or imprisonment. But the discharge is regarded as a very serious sanction. And so it's important that the application is formulated in such a way that is appropriate to the seriousness of what is being applied In some cases, if you look at the authorities, the applicant for discharge runs the risk of burdening the court with identifying numerous fairly minor complaints. My advice would be that it's prudent usually to identify the most serious, egregious, the courts would say, breaches, so that you can identify a particular missing point that should have been brought to the attention of the judge, or identify something that was said in the evidence or in submissions which was false, and which you can say these were clear cases where the duty of disclosure was breached. There is a danger if you overcomplicate the matter with numerous pieces, with numerous points, and with heavy evidence running to file after file. There's a danger that the court will be unable to see the wood for the trees. Having said that, the quotation I've given on that slide is taken from a judgment of Mr. Justice Jacob, where he actually went on to consider the application to discharge, which was made orally by leading counsel at the continuation hearing. But the judge then held that he would have dismissed the application to discharge on the grounds that insufficient notice had been given, although he went on to say that the application to discharge had no merit at all. So what are the principles on which the court will determine whether to discharge an injunction on the grounds of breach of duty or make some other order? The principles that I've set out there are taken from a judgment of Mrs. Justice Carr in a case called Tugashev and Orloff. That was recently cited with approval by the Court of Appeal in Valbonne Estates and City Value Estates. I'll be referring to another decision, which is often cited, the decision of Mr. Justice Clark. But in the light of the Court of Appeal approach in Valbonne and City Value, it is probably better to take Mrs. Justice Carr's formulation as the starting point. Interestingly, and all the formulations put it in this way, the starting point is immediate discharge without renewal if the failure is substantial or deliberate. And that means that the court will discharge the order even if the order would still have been made had the relevant matter been brought to the court's attention at the without notice hearing. And there you see that Mrs. Justice Carr said this is a penal approach, and intentionally so by way of deterrent to ensure that applicants in future abide by their duty. So that emphasizes the importance of the duty that Doug was discussing. But some points perhaps need to be made in relation to that starting point. The first is the non-disclosure must be of a relevant matter. And that's been explained in elsewhere as meaning that the applicant for discharge must identify the point which was material to the issue which the judge had to decide. It's not good enough simply to identify peripheral points. You must say this point, whether it's a matter of fact, evidence, law, or some other matter, should have been brought to the judge's attention because it would or might reasonably have had an effect on the actual decision to be made. So the matter must be material. Second point, as Doug mentioned, it's not usually relevant to ask whether the fault for the non-disclosure or misleading the court is the client's or an oversight or mistake by the legal representatives. The client will not usually be able to hide behind their legal representatives. The sanction will be the same. The third point is that this is the starting point. And perhaps as so often in matters of this nature, where there appears to be quite a severe starting point, that is not the end point. And moving on, the court has a discretion, notwithstanding the fact that there may have been serious non-disclosure. The court will always have a discretion, and I deal with that on the next slide. Again, Mrs. Justice Carr indicated that the discretion should be exercised sparingly, but the overriding objective is always the interests of justice. So that means that a focus is on the importance of the facts not disclosed. Put another way, that means that one does look at the merits of the case as it is now before the court to see whether the facts not disclosed actually affect the merits of the case for granting the injunction. The need to ensure proper compliance, that simply restates the starting point. Whether or not and to what extent the failure was culpable, as I've said, that's relevant, but that doesn't mean that the client can say that he's not culpable because the legal representatives didn't make that disclosure. They must be seen as a team. The question is whether the client / legal representatives made the appropriate inquiries or, for some reason, sat on information that they should have disclosed. And finally, though, the injustice to a claimant which may occur if an order is discharged, leaving a defendant free to dissipate assets. So it is relevant to go on and look at the merits of the case as it is before the court. In the other case that has frequently been cited, the Ugancraft and Severe Energy, Mr. Justice Clark put it slightly differently. The stronger the case for the order sought, and the less serious or culpable the non-disclosure, the more likely it is that the court may be persuaded to continue or re-grant the order originally made. In other words, although the starting point is that serious, culpable non-disclosure will lead to a discharge of the injunction, the court will still look at the merits of the application itself. And if there is still a strong case for the order sought, then discharge may be refused, or the court may discharge the injunction but then go on to re-grant it. So, put very simply, it's a balancing exercise, and it perhaps is, in that time-honoured phrase, all one can say is that it is fact sensitive. In the UGRANF cases, the application had actually been for the appointment of a provisional liquidator. For various reasons, the court decided that the underlying claim should be dismissed, and that meant the winding up petition was also dismissed. But Mr. Justice Clark went on to consider what he would have done if he had allowed the commercial court proceedings and the petition itself to continue, the winding up petition. But he held that evidence that had been filed in another jurisdiction should have been disclosed, and the extent of non-disclosure was such that even if the court had allowed the claim to continue, it would still have set aside the order appointing a provisional liquidator and consequently dismissed the claim itself. So that was a case where, albeit obiter, the judge held that although there was a claim for a provisional liquidator on the merits, he would not have he would have discharged that order in any event. The way he put it was this: the matters not disclosed were not peripheral to the case which UGRANF sought to assert, or to the alleged urgency of the application. Whilst I have no doubt that there was no intention to mislead, I am satisfied that whatever reason inadequate disclosure was made, and the extent of the non-disclosure is such, had I not struck out the claims, I would have set aside the order appointing a provisional liquidator and dismissed the claims. He pointed out it would have then have been open to the claimants to commence new proceedings. So even though there was no intention to mislead the court, he held that the appropriate course was to discharge the order. But of course, that was not a freezing injunction, and different considerations might well apply in that situation. as Mrs. Justice Carr pointed out in Tugashev, it's not always necessary to discharge the order. There are alternative sanctions available, and of course that could include a cost order. In other words, cost relating either to the injunction itself, or an adverse cost order for the application for discharge. And of course, typically, an application for discharge is likely to be a very expensive exercise. Moving on, I've dealt with, I mentioned briefly the question of timing. In the normal case with a prohibitory injunction, a freezing injunction, you should make the application as soon as possible, and it will have to be brought on as soon as reasonably practicable, given the need to file evidence on both sides. But in cases where, for example, a search order has been made and the order has been wholly executed, there seems to be a difference of opinion. One view is that any application should be dealt with at trial because there's no point discharging immediately. The order's been executed. The alternative view is that it's really a matter for the discretion of the judge. Finally, I've included a note on the case of Balbon Estates and City Value, which was a case of an injunction to restrain an imminent property sale. There had been very serious failures to present the case fairly. There had been arbitrations in front of the Bet Din, and the applicants didn't actually disclose to the court in full what the awards had and didn't disclose in full the full terms of the award. Interestingly, the Court of Appeal accepted that the court could approach a discharge application of that type by looking forward as well as backwards. In other words, following the approach of Mr. Justice Clark in Ugranev to look at what the effect is going to be in the future on the claimant. But this was not a mandatory approach. There are no hard and fast rules which must be applied, and the court should take into account all the relevant circumstances. And although the court agreed that it was right to discharge the injunction in that case, it's important to note that a very significant factor in the determination of both the judge and the Court of Appeal was that the sale that they were trying to prevent had probably completed anyway. In fact, it appeared to have been completed on the day the injunction had been granted, before notice of the injunction had been given. So the injunction was of no practical effect. So that is, in fact, an illustration, in a way, of a case where the court, looking forward, thought that there was little purpose in any event in continuing the injunction, and therefore, put crudely, it was an easier decision to make to discharge the original injunction. We then have time for questions. I'm not sure whether there are any further questions.
There are some appearing in the chat now. The first one being specifically addressed to you. So I'll summarise how I've been reading this that came through. The principal factors for these, an application is made not on notice in the usual way, it's made on notice, and it appears what has happened here is the court has decided grant an injunction without having both parties or cross undertaking being given unusually, and then has set down a return day. Now, the questioner has said that on the facts of the case, the matter was settled before the return day came back. What would their status be when it comes to the duty of full and frank disclosure? The questioner suggests that it might be said that actually they should have gone back to the court and said, hold on a minute, if you're going to be doing that without having a vote from the other party, then actually we should give you some full and frank disclosure first. So what they have done that, or could they just do as they appear to have done and simply served the injunction order and said, well, that's what the court gave us, so we're not going to look a gift horse in the mouth?
I think I need to look a little more carefully at the facts, and I'm happy to do so afterwards. If proper notice has been given, in other words, if 3 days notice was given and there was no application to adjourn, then on the face of it, the duty of full and frank disclosure I don't think would apply. If the other side don't attend, then I think as a matter of practice, one would usually bring to the court's attention anything which had been raised by the other party in pre-action correspondence. But I don't think I would criticize the applicant for serving the order. The answer is that the respondent, on receiving the order, should have taken advantage of the permission to apply, which should have appeared in the order, and taken advantage of their right, I think, under the rules, to apply to set aside any order made in their absence, and made an application themselves simply to set aside on the basis they wish to oppose in the normal way. I'm not sure from what you've described there was necessarily non-disclosure, but I may have missed that.
The next question is, do you have a view as to the current price, in quotes, that court judges seem to be putting on the levels of cross-undertakings and indemnities? Is there any current rule of thumb? I'll take a quick crack at this, Neil, and then you can add your expert wisdom. I would have thought that the general golden rule would be to say these are the plausible outcomes which could be deleterious to the respondent if the application is granted and we turn out to be in the wrong. These are the things that could go wrong for them. Here are the resources that we have to cover them. And then you try and sketch out what it might be, and it might be quite obvious how it is that the respondent could lose out. And then you attempt to demonstrate that your resources are sufficient to cover that contingency and give an undertaking to cover it. So it seems to me that the golden rule there would be, what's the likely damage, and do you have the resources to match? I don't know if Neil has a view on that.
I agree. There isn't a rule of thumb. It depends very much on the facts of the case and upon what is the nature of the injunction you're seeking and what the potential effect will be, exactly as Doug says. So the answer to is there a rule of thumb is no.
I think that exhausts our questions. Thanks very much for attending. The slides will be sent out and will also be posted on our website, along with a copy of the talk, so you can watch it again at your leisure if you wish. Thanks very much for attending, and have a good morning, everyone.